Good afternoon, everyone. Thanks for joining us today. I'm Amy O'Hara. I'm the president of the Association of Public Data Users, and I want to thank you for joining us. This is going to be Demystifying Data Privacy, Part 3, where we dig into the very oddly named routine use exception to the Privacy Act, which is neither routine nor a use. But first, a bit of housekeeping. If you have a question, please drop it in the chat or the Q&A. We will track both, and we'll do our best to get to your questions throughout the presentation and at the end. And if we don't get to your question during today's session, please send us an email at info@appdu.org. Now, for those of you who might have missed the first two webinars in this series, I'd encourage you to watch the recordings, and we'll put a link to them in the chat. So our special guest star today, I'm going to give a brief introduction. You may have heard that people are concerned about data privacy, and recent polling from the Center for Democracy and Technology suggests that concerns about data privacy are widespread and bipartisan. More than 80% of people across the US say that having legal protections for sensitive information that government agencies have about them is important, but less than half of them know their rights. It's not just the general public that has these knowledge gaps. As we've been embarking on this work, it's clear that our friends in the AppDo community, people are just aware that there are these information silos because the data people are talking to data people, tech to tech, legal to legal. And so there's also some questionable information out there. People don't understand even the definitions. So with support from the Annie E. Casey Foundation, we brought together a team of experts to help fill those gaps and raise awareness so that we can all work more effectively together to strengthen data privacy protections. Today, we're talking about a quirky little exception to the Privacy Act known as the routine use exception. And I'm pleased to introduce Maya Bernstein, who served as the Senior Advisor for Privacy Policy in the Office of the Secretary of HHS for over 20 years until April of 25. She helped develop and implement HIPAA, worked in privacy at IRS, and HHS was awarded the Federal Privacy Council's Award for Excellence. If you've heard either of the first two trainings in this series, you know that Maya is an expert, and I'm delighted that she's here again to share some of what she knows. Maya, I hand it over to you.
Thank you so much, Amy. I'm delighted to be here with all your guests and everyone who's joined us today. I want to talk, this is a little agenda of what we're going to talk about today. I'm going to do a little review for those who may have missed either of the first two webinars that AppDo has sponsored. I'm going to talk to you about what is this thing of routine use, compatibility, which is part of its definition. I'm going to talk procedurally about how you get them, and then with some examples about what a good one looks like and what a not so good one looks like. And then hopefully we'll have some time for your questions, but please feel free to put questions in the chat, and Amy and her colleague Beth behind the scenes are gonna, moderate the chat for me, and feel free to interrupt me if there's something that seems to go with whatever we're talking about at the moment. With that, let's go ahead. Just a quick review about the structure of the Privacy Act. The Privacy Act imposes obligations on federal agencies, grants rights to individuals about whose records the federal agencies are maintaining. It incorporates something we talked about the last couple of times called a Code of Fair Information Practice that implements fairness codes across the entire life cycle of information. So from collection and maintenance and use and disclosure and eventual disposition. And then, of course, it imposes some civil and criminal penalties, which we talked about last time. So the couple of important things that you need to know for this particular little training are the definitions of record and the definition of system of records, and we're going to talk about that. So just to review, a record is, well, I have a shorthand for a record that really is two elements. It's information about an individual that's connected to an identifier. So what's a personal identifier in this context? Pretty much almost anything can be an identifier, as long as it directly identifies the individual. It does not have to be unique. So in the example that we gave in our little issue brief, we gave the example of Rosalie. Someone named Rosalie might not have a unique name, but it's her name and it's directly related to her. That counts, even if there are many Rosalies. It does not have to be unique. But also a photo of Rosalie's unique tattoo is a full record because a unique tattoo is a personal identifier. It identifies Rosalie. And the information about her that is connected to that identifier is the fact that she has such a tattoo. Remember that, as I said, that for the Privacy Act, they have to be direct identifiers. You can't put together a birth date, gender, a zip code, and put it together and figure out who people are. That's not a direct identifier, even if you can identify somebody that way. There's no probabilistic matching. Somebody had this very smart question last time around. They asked us if you can use probabilistic matching. You cannot in the Privacy Act. That doesn't count as a record. And so anything that fails one of these elements that you see here on the slide, whether it's not a record, it's not maintained by an agency, it's not about the person, and so forth, any of those will fail the test of whether the thing is a record under the Privacy Act. An example that comes to mind, a good example for this community that may be helpful is that it's not a record if, for example, you have a restricted access file that agencies create that may contain a date of birth, it may contain gender, zip code, and maybe all kinds of medical information or a wide variety of personal information about somebody, but are only identified by some kind of randomly assigned number. So that's not a record, even if you could re-identify the person fairly easily. Okay. And then we have a system of records. And the concept of a system of records is really the linchpin of the Privacy Act. Everything else in the Privacy Act, almost everything else, I should say, relies on this definition. So what is it? It's a collection of records, the thing we just defined on the previous slide, where the record is retrieved by that individual identifier. So 50 years ago, when the Privacy Act was passed, you can imagine what the Congress had in mind was a file cabinet. You pull out the drawer and you see an alphabetical list of files, and you can go to the B's and find Maya Bernstein and pluck out her record. You don't have to go through every file in the cabinet to get to her. Or they imagined a numerical list of files like Social Security numbers in order, where you could go to my number and pluck me up without having to search through every file. And that was just a way of containing what was covered and what was not. They didn't want to cover every piece of data in the world. They wanted to have some scope around it. And that's the way, and 50 years ago, they decided to do it. These days we have full text searching database and so forth. It may seem a little arcane, but that definition still works if you're searching through a database and you're searching by somebody's name or number or even facial recognition. You're calling people up by their face. That counts as retrieved by the identifier. Examples of things that are not systems of records. So you have an office correspondence file. Typical thing that at least federal offices and maybe many businesses keep is a correspondence file in chronological order. That's not a system of records. It may have a lot of personal information in the correspondence, but you can only find it by date. To find Maya's file, you have to go through every date. Or, for example, a group of census data organized by MSA, by the Metropolitan Statistical Area, not a system of records. However, be careful, because if the data are organized by street address, a street address could be a personal identifier, especially if there's only one person who lives at that address. That's directly identifying the person who lives there. Records organized by subject are also not a system of records, even if the records are detailed. So if you have a bunch of medical records, but they're organized by diagnosis, that's not a system of records. So remember that a system of records is a logical description also of a group of records, meaning it's not defining an actual IT system. It's not defining just a file cabinet. It could be multiple IT systems that form one system of records. It could be that one system of records contains multiple IT systems. They're not coterminous. A system of records is a logical description of records. Okay. Just checking if there are any questions at this point. Just give me a pause here.
There was a question in the chat. So what is information about someone, for example, with the statement, person with this tattoo was in front of the White House on this date, be a record?
Yes, if it says yes, actually that's an example, right? So any information about somebody could be about them. About turns out to be important in some cases. For example, one example we use is if you have a record of your contractors, multiple contractors, and you have the contact information for, that business, the fact that the person's name and work phone number are in the record about the business, it's not about the individual, it's about the business. So that is not considered to be a record under the Privacy Act. That's about a business. Businesses don't get privacy. But a record about an individual about when and where they are at a particular moment, whatever they're doing in front of the White House, that could be information in a record if it has either their name or if it's retrieved by the tattoo, if all you have is that tattoo, and an agency could retrieve by a photograph, by matching another photograph. Like that's amazingly something that I always find is surprising that the Privacy Act contemplated 50 years ago. It says, it could be a photograph, it could be a voice print, and that they anticipated that one day we might be able to retrieve records by a photograph or sound is pretty incredible to me, but that's what they meant. So information that has either Rosalie's name or a picture of her tattoo connected to information about her, where she was on a particular day, what she was doing, that's a record. It's only a system of records if they're retrieving the information either by her name or matching the photograph or her tattoo and calling it up that way. I hope that's clear.
Great, thanks.
Great. Okay, so one more reminder, which is getting to our subject today, and that's about disclosures. The basic rule in subsection B of the Privacy Act is that there shall be no disclosure without the prior written consent of the subject individual. That's the presumption, the default. And then there are a bunch of exceptions, and most privacy laws are organized like this. You need consent, but here's a bunch of exceptions. And you can imagine that the Congress put these in because it didn't want to make the government incapable of functioning. There are certain kinds of things where you have to move data around to do your work or to carry out your mission. And they anticipated, 12 of them. And we went through the most important ones of these in the last session. Today, we're going to focus on just one, this one that you see here, B3, the routine use. A routine use is, as Amy was saying, it's very flexible and maybe the most misunderstood of the disclosures. And so why is it in there? Well, the Congress couldn't anticipate every possible disclosure that agents would need to carry out their work. So it created what I think of as a policy escape valve. They provided a way to add new disclosures where consent doesn't work and where the other statutory provisions are not sufficient. And they can add these disclosures if they follow an administrative process that was set up by the Congress. So what is a routine use? Okay, so here there are just the other disclosures. I left them in here for completeness, but we're going to talk about this one that's highlighted B3. All right, what is a routine use? As Amy said, a routine use is neither routine nor an internal use of information. Discuss, right? For those of you who are Mike Myers fans. It's a silly name and it causes a lot of confusion. And in particular, people get it confused with the B1 disclosure. If I go back 2 slides, B1 says you can disclose inside your agency to other officials who have a need to know in the conduct of their business. Well, routine use sounds like that. It sounds like something habitual, and it sounds like something that's an internal use of information, and that neither of those things are true. But it's the language that we're stuck with. The B1 disclosure, this need to know inside the agency, that is actually more likely to be habitual, or routine, although it doesn't have to be. So unfortunately for the understandability of what the Congress meant here, what they defined was that a routine use is the disclosure of a record outside of the agency, by which we mean a whole department, the whole department of HHS, or the highest level of an agency if it's not a department, for a purpose that is compatible with the purpose for which the information was collected. So as I say, unfortunately, the Congress never defined the word compatible. And that makes it hard to understand. Fortunately for me, I can make a living explaining what this stuff is about. But without a definition, that leaves the agency to figure out what it means to be compatible with guidelines from the Office of Management and Budget. OMB is the agency responsible in the law for doing oversight of the Privacy Act. And sometimes, and the Congress maybe, but sometimes the courts. These can be taken and challenged in court. So what does compatibility mean? I put compatibility into, I sort of divide it into three categories of kinds of things that could be compatible. First, we have things that are directly related, meaning the disclosure you're making, there is a nexus between the disclosure you're making and the purpose for which the information was collected, and this disclosure directly supports the primary purpose that you are collecting or managing the records for your program. An example of that would be if an agency shares employee data with the contractor that they've contracted to do their payroll. You have to pay your employees. It's not your program mission. For the HR office, of course, it is their program mission. And if they contract that function out, you have to give the records to the contractor in order to perform that function. That's a directly related kind of disclosure, and those are completely reasonable. That's pretty much what the Congress anticipated. But there are another two kinds that might come up that are also acceptable. The next one is what we would call necessary and proper. And this is what happens when you have to make a disclosure that might not be related to the reason why you collected the information. But if you don't make that kind of disclosure, the program would fall apart or the integrity of your program would somehow be harmed. So, for example, if CMS, which runs the Medicare program, it doesn't, if it were to make a disclosure to the Department of Justice because it's discovered that there might be some kind of fraud in the program. Look, Medicare does not collect records to turn over to justice to investigate fraud. They collect records to pay insurance claims, right? They pay doctors and they pay people who provide care, and they're an insurance company that reimburses providers of care. But if they didn't disclose to DOJ to investigate and prosecute Medicare fraud, eventually we would have no Medicare funds. So they have to do that in order to support the integrity of the program and to make sure that it runs fairly and accurately and appropriately. So that's also an acceptable kind of routine use. A third kind is what I've come to call a collateral routine use. And this is a thing where there might be absolutely no relationship to the purpose for which the information is collected, but Congress says you have to do it. So if there's another federal law that says you agency must disclose your data to this other program, even if it's completely unrelated, you have to do it because the law says so. An example of that, and this happens a lot, is that the IRS discloses information to other agencies so that they can test income levels for means tested, benefit programs. IRS, of course, collects our information to administer the tax program. It does not collect information to figure out whether you're eligible for Medicaid benefit or for SNAP, for food stamps. However, the Congress has said you must disclose that information to those other programs to help them. And that has basically created the compatibility. The Congress has created the compatibility in that case. So keep in mind those three different types of routine uses: directly related, necessary and proper, and collateral. Okay, I'm going to pause and ask if there are any questions about that for a minute. I don't see any for the moment.
There was a question popped in the Q&A.
Okay.
Let me get to that.
I think I'm just looking at the chat, so
All
thank
right.
you.
Sure. Given the so-called mosaic effect, otherwise known as the ability to re-identify using a compilation of multiple pieces of information, is the definition of a record potentially allowing for re-identification using information that isn't a personal identifier?
Um, okay, yeah. So that's a good question. We have this other term that has, well, so let me step back for a minute and say, remember that the Privacy Act was written, it was passed and signed in 1974, was probably developed in 72, 73, and it's very old, right? The kind of technology and the kind of sophistication we have about records, even if it existed then, it was not in widespread use at all, which it is now. And so the Congress, when it passed the Privacy Act, didn't really contemplate that. We have other laws that have come along later that have considered that. So, for example, the Electronic Government Act, which is the thing that created the requirement for privacy impact assessments, that's the thing that defines PII, personally identifiable information. PII is not a term that ever appears in the Privacy Act, is not associated with the Privacy Act. It came much later. But OMB has defined that as information that identifies somebody or combined with other data could identify somebody, much, much broader definition that's covered in that law. And that's, the kind of thing that was recognized later, but is not an issue in the Privacy Act. If the Privacy Act requires there to be a direct identifier. And yes, it's possible that it's possible to re-identify people based on Privacy Act information or where it's moving around, but it just the Privacy Act is old. It needs to be updated. And that's one of the areas where the definitions of record and system of records might need to have a new look.
Got it. Thanks. Another question, does this apply to information collected for statistical purposes, such as census data?
So census data in its raw form can be a system of records. I should have looked up, but I'm pretty sure there is a system of records for census data because a census taker goes house by house, looks at you house by house, has your name, has your address, and has lots of information about you, and can pull it up by very, very narrow cells or even by individual houses and so forth. Now, that's not necessarily something that will be disclosed to the public, but for the agency's own use, they do have very detailed information, and you can look it up that way. Remember that just because you can look it up that way doesn't make it a system of records. But if the agency ever does that, or if it routinely does it even in a small area, that would be a system of records. So yes, I believe that where the information is identifiable in the way that the census records are, they're at least records because they're information about an individual with direct identifiers, names and home addresses of, for example, people who are the sole person living in a house, connected to all kinds of information about them. In order for it to be a system of records, they have to be retrieving by that name. When you get to the compilation of the data that's made public for statistical purposes, it's not retrieved by that. And so those publicly made available filers are not systems of records. But internally, I think Census does record those as systems of records under the Privacy Act. Does that make sense?
Yep.
Okay, great.
Another question, what about IRS data that is turned over to DHS under the Patriot Act?
I'm not sure what the particular provision is that one is referring to, but IRS data, to the extent that it refers to individual taxpayers, I didn't give you the definition of individuals, but it's also important to know that only living natural persons are covered by the Privacy Act, not businesses. And so if it's a business taxpayer that's turned over, they're not covered by the Privacy Act. It also only covers citizens and permanent resident aliens, officially. If you're interested in that topic, because it's a little complicated, we did do a 2-page on what's called mixed systems. What happens when you have people in different immigration statuses mixed together in a system, which is what you have in the IRS systems, right? Taxpayers may be in all kinds of immigration statuses, and the only ones that officially get Privacy Act rights are those that are citizens or permanent resident aliens. When that data moves over to Homeland Security, if the Patriot Act required it to do so, it falls into this third category of collateral routine use. It's important to know that the fact that a statute says that an agency must disclose the information doesn't by itself allow them to disclose if it's covered by the Privacy Act. The Privacy Act does not have an exception that says if some other law permits you to disclose, then you can do it. The Privacy Act says you have consent or you have an exception. So that means you need to use the routine use exception. You need to draft a routine use. It's going to cite the statute and say, the Patriot Act requires me to make this disclosure. You're going to send it out for comment. And then they're going to disclose because the law requires it. It doesn't really matter what people comment on if the law requires it. But the Congress has there added the compatibility for sending information to Homeland Security, assuming the law required it. There are times when Treasury, and we're going to talk about some examples where Treasury is making broad disclosures, and I'm going to show you examples of things that are, let's call them dubious routine uses from Treasury to other agencies.
Okay. Another question.
Okay.
Could Congress legislate disclosure of PII that is clearly a serious violation of privacy? In that use case, would be explicitly harmful to the individual, such as immigrant legal status?
Okay, so again, so the Congress can, if both houses of the Congress pass a law and they can get to the president to sign it, it's the law. Until the Supreme Court knocks it down as being unconstitutional, it's the law. So yes, the Congress can do that. Underlying your question that has to do with, immigration status. Again, the Privacy Act only protects in its official coverage citizens and permanent resident aliens. Technically, even if their records are commingled, people in other immigration statuses, whether documented or not, do not get Privacy Act rights. That is something interesting because in Europe, people in any kind of immigration status do get Privacy Act, their privacy rights, and we don't protect Europeans who come over here in the same way. And that's been the source of disagreement and negotiation, trade negotiations over cross-border data flows and so forth, but is a topic for the mixed system brief, and I urge you to go look at that if you're interested in the topic of what happens with immigration.
Great, thanks. Another census one here. It's a statement, and then the question is going to be, is this the right way to think of it? So the statement is Title 13 of the U.S. Code that contains the Census Act has privacy for Census Bureau records to be confidential with a system of strict penalties. I don't think it has to rely on the Privacy Act. Is that the right way to think of it?
Correct.
So,
yeah, Title 13 is a very strong law. In fact, the Privacy Act has an exception that says if the census needs the data for Title 13 purposes, you can disclose it. The Congress anticipated that. Title 13, and I'm not an expert on census or Title 13, but it is one of the strongest privacy confidentiality laws that we have. And so the Privacy Act is a general law, but if you have a law that is more specific and particularly targeted to a type of data, lawyers will tell you that the laws of construction about law tell you if you can make both laws work at the same time, that is what you should do. And so there is nothing in the Privacy Act that says you can't protect something more like under Title 13. And that's what happens. Census is very careful. Well, historically, Census has been very, very careful about protecting Title 13 data and keeping that confidential.
Great, you're all caught up.
Okay, great. Thank you. All right. So procedurally, how does an agency add a new routine use? When it wants to make one of these new disclosures, the Privacy Act requires them to publish a new or a modified system of records notice in the Federal Register. They have to publish the notice for at least 30 days and keep it open for public comment during that time. And only after that time can they actually use the routine use to make a disclosure, to rely on the routine use to make a disclosure. On the first day a system of records notice is published in the Federal Register, an agency can collect information, it can store it, it can maintain it, it can use any of the other statutory exceptions to disclose information, but it cannot use a routine use for 30 days. Before this happens, then agency also has to, under OMB guidance, again, OMB is the statutorily assigned agency to do oversight of the Privacy Act. OMB has asked that agencies send a report to OMB and the Congress with a narrative statement describing what they are doing. And it discusses how it is that the agency thinks that their routine uses are compatible with the reason for which the information is collected under one of these three theories that I talked to you about. And that report has to be sent to OMB 40 days before publication in the Federal Register, giving OMB time to comment or adjust or negotiate with the agency. One thing that's useful to know is that when an agency publishes, and we talk about this in the AppDo document that talks to you about how to review a system of records notice, there's a preamble that comes that explains what the agency is doing. But also there's this report that goes to OMB, and I'm pretty sure that if you requested it under the Freedom of Information Act, you could get that. Or if you know somebody in the Congress, you can get that report and see what the agency told OMB about what it was planning to do, what its explanation of was what it intended to do with this system of records and its routine uses. For this reason, though, routine uses can be kind of written in legalese. They're legally binding. Once they're published and they go through the 30-day comment period, they're available to the agency and they're legally permissible. So looking at the preamble that's part of the notice or finding one of these reports can be helpful in understanding what it is the agency intended or discerning the agency's intent at the time that it published. Okay, so what does the law say about what are the elements? What is a notice about routine use have to contain? The Privacy Act dictates that a routine use must include to whom the records will be disclosed and for what purpose the records will be disclosed under the routine use. It is good practice and is also OMB guidance that recommends that an agency also includes what data elements will satisfy the purpose if the entire record does not need to be disclosed. Like I'm only disclosing the name and the address here, not the entire medical record that I happen to have, or whatever, for whatever the purpose is. Without citing those limited elements, the language could look like an agency can disclose a whole record, and it's often useful to kind of circumscribe the amount of data that would be disclosed under a routine use. But this is a place when it's drafting, an agency could add other requirements for policy or security reasons, such as disclosing only in the presence of a data use agreement between the parties, or that a request for information to which an agency responds using their routine use has to be in writing and signed at a particular level of the requesting party's organization. Or, for example, that the transfer only happen in a secure environment, that it be encrypted. Now, you wouldn't want to dictate particular technologies because technologies change over time. You want that to be flexible, but you can put the notion in your routine use that we are only going to disclose in a secure environment. You can add an agency can add into its routine use things that will circumscribe and help protect the data that it is the custodian of. Okay, so what kind of routine uses are common? We've been talking about them sort of in the abstract, and I wanted you to have an idea of, well, what does this language really look like when it appears in the Federal Register? The second example here is the one that appears in our issue brief, but here's a couple of typical ones. First, to a contractor, it says, to agency contractors, grantees, experts, consultants, and some agencies even include volunteers who've been engaged by the agency to assist in the performance of a service related to the system of records and who need access to the records to perform the activity. I want you to think about under which of the three categories does that contractor provision fall under? Is it a directly related routine use? Is it necessary and proper? Is it collateral? Is it easy for you to understand, or do you have an idea of where that falls? For me, I think this looks like a directly related one. It's kind of like the example I gave you of the contractor carrying out the payroll, but a contractor could be carrying out any kind of function where they need the records in the performance of that duty. And this is what the routine use might look like that would allow that kind of disclosure. The second one for disclosure to NARA, that's the National Archives and Records Administration. You may have noticed that in the original disclosure provisions in the statute, there is one that pertains to NARA. That one, however, allows an agency to disclose to NARA when it's no longer needs its records and it has been decided that they are permanently valuable and they're going to be accessioned into the permanent collection of the National Archives. This is for a different purpose. This is for records management inspections. That's a statutory function. It's something else it's the records administration part of NARA rather than the archives part. And that one, I would say, maybe both falls under both necessary and proper. You want to have good records management for your program to run correctly. And also, it could be considered a collateral routine use because the Congress has said you need to do records management inspections. That means you need access to the records. And here they've cited the statute that requires that function. So it could be either one of those. Here's another example, one that we commonly see. Says you can disclose to a member of Congress or their staff member in response to an inquiry at the written request of a constituent. Now, what is this thing about? You see it all the time. And again, there is an exception in the Privacy Act to disclose to committees of jurisdiction but those are for oversight functions, right? That's when the committee is holding a hearing, it's doing oversight, it needs records in order to support that hearing, and the chairman of the committee, or the Speaker of the House, or the Majority Leader in the Senate, the person in charge, whichever party it is, requests the records. And this can be, so that kind of function is already in the statute. What this is for a member of Congress's constituent service function. And really, it's for the convenience of the member of Congress. It's a courtesy between branches of government. Instead of making the member of Congress go back to the constituent when they have a request to get a formal consent on some particular piece of paper that the agency dictates, basically it says anything you show us in writing that evinces a desire for the member's assistance to help that constituent, we're going to accept that. And we're going to respond to that and give the records to the member of Congress so that they can help their constituent. One interesting wrinkle here is it must be in writing. You'll often see ones that don't have that it has to be in writing. Those are very suspect. And the reason is when you get a phone call and the phone call says, I'm a staff member for, Representative so-and-so or Senator so-and-so, how do you know it's really them? When they ask you for records about a particular individual and you're the custodian of the record, you want to make sure that you're really responding to an appropriate request. And I have seen in my history in the government that it has happened on occasion that the staff member is writing and asking information about a constituent, but that constituent turned out to be the member's opponent in an upcoming election. That is not okay. That is why you want the request to be in writing. You want to make sure that the constituent really asked for the help. Okay. Just looking at the time a little bit. Okay. One more common routine use that you're going to see a lot and that I think people are concerned about lately. This is a reporting to law enforcement, and this is the kind of language you're going to see, very legalistic. When a record on its face or in conjunction with other records indicates a violation or a potential violation of law, civil, criminal, regulatory, whether it's general statute or particular program, regulation, rule, right? It goes on like this. Then it says disclosure can be made to the right agency, whether it's federal, foreign, state, local, tribal, some other public authority that's responsible for sort of anything in the panoply of law enforcement kinds of stuff. Could be investigating, pursuing, prosecuting, and so forth. That looks like a lot of legalese. And the reason for that is pretty much every one of these phrases is related to some case where a previous routine use was found not to be adequate. An example of the first phrase where it says a record on his face or in conjunction with other records, well, there was a case where the routine use that got challenged said, when a record shows a violation of law. And in that case, it wasn't the record. It was only when you combined the record with some other records that you could figure out that something squirrely was going on. And that, therefore, the court threw it out because the routine use didn't say that. So over time, these routine uses have come to have these, kind of complicated language that sort of, covers the rear end of the lawyers and of the agencies. They're protecting their agencies, rights and legal obligations and so forth. And so that's why you get language that looks like this. So what category would you say this falls under? I would say this is the typical kind of necessary and proper routine use. You find fraud, you need to turn it over to the right agency that's going to, figure out what's going on with the fraud. If you're a federal agency funding a state program, that might be a state agency, it might be the federal agency, but you're going to put it in the place where the proper entity to investigate is sitting, and you're going to disclose what you need to give them the opportunity to investigate that crime. Okay. I put another one here. This is another example. For court filings, generally they become a matter of record, public record. If you're ever in a situation where you're involved in litigation that involves you or someone else's Privacy Act records, a good idea to ask the court to disclose under seal or with protective order, or some other action that will protect the records. But this is a routine use that says, I can make a filing in court of the record if I need to. Okay. Now I want to talk to you a little bit about dubious routine uses. These are things that really don't pass muster, or if you're looking at a system of records notice, you should be wary of. First, anything where the program purpose isn't clear. If you're commenting on a system of records notice, you should be asking yourself, well, what's the nexus between this disclosure that they're asking to do in the routine use and the actual program that they're running? You should be concerned about any disclosure that duplicates an exception in the Privacy Act, and that's because, as I said at the beginning, the main rule is that the default rule is that you have to get the person's written consent in advance. If you can't get that, you should look to the statutory disclosures, and only then should an agency be creating a routine use to do something else. But if the statute has provided you a way to do it, that's a stronger leg to stand on. Routine uses can be challenged in court. As I said, the language sometimes gets thrown out. You have to rewrite and start over. And so it's important not to duplicate anything that the statute has already provided. And that's similar to the third bullet here. Anything that has to do with subpoenas or discovery. Why is that suspect? It sounds good. It sounds legal. A subpoena is a thing you normally have to respond to. Well, and that's because the Congress has provided a statutory exception that says you may disclose under the when you have an order of a court of competent jurisdiction. That means a federal court. That means a judge has to sign the order. You can't get around that or water down what the Congress has told you have to do by saying, well, it's too much work to get a court order. I don't want to go to court every time. I have to make a disclosure here. I'm just going to get the U.S. attorney to write a subpoena, or I'm going to have the clerk of the court, write me an administrative order or something like that. That's not okay. There's been a lot of litigation about it. You must get the judge to sign it. And by extension, I would say any other routine use that you try to write that waters down what the statute says, people are going to cite those cases and say you can't really water down a routine use. Water down with a routine use something that the statute provides that's more stringent. Finally, something that comes up very often is disclosures for background investigations. That happens a lot, of course, in federal service, but also background investigations are done for all kinds of jobs in the private sector using federal data. And you might see a routine use that says, we're going to respond to a request when somebody's asking for our information in order to do a background investigation. That is a no-no. Normally, when a background investigation is being conducted, the applicant has to sign a piece of paper with a very detailed consent. And that is the way that the Privacy Act contemplates that a disclosure should be made. If an agency wants information for a background investigation, they should present the written consent that was given to them by the applicant, and the agency can then rely on that document to disclose information. It shouldn't be using a routine use that can be challenged. Okay. I want to talk about some actual examples of routine uses that we have seen recently that will test your knowledge a little bit. So think along with me about what if you saw this routine use. In fact, this was published just in February in a Treasury System of Records notice, and it had this long and complicated language in it. So does anything strike you as improper about this? And maybe people want to put in the chat, that's okay with me. If you see something that looks funny or squirrely to you, you can start with the first phrase. Is there any entity? So it says to federal agencies, non-federal entities, including states and local governments, their employees and agents and contractors and so forth. Is there any entity worldwide that is not either a federal agency or a non-federal entity? Pretty much everything else is a non-federal entity. And so that phrase does not actually constrain the Treasury Department in any way. The statute requires that you say to whom you're going to disclose information and for what purpose. And the to whom here means anyone in the whole wide world. That's not good enough. Look with me at the second listed purpose. What does it mean to disclose for the purpose of identification and prevention of fraud, waste, and abuse? What exactly? What does it mean to disclose for that purpose? Even if I understand that's the purpose, can I understand anything about what Treasury is doing by that? Does it narrow what Treasury can disclose? Does it constrain them in any way? It's really not clear. And then for what programs does this routine use permit the Treasury Department to disclose records to help them ferret out fraud and abuse? Well, it says federal programs administered by the department. Okay, that's Treasury. That seems reasonable. Then it says, or another federal agency. Okay, we're federal partners and we help out other federal agencies. But then it says a non-federal entity. I saw that and I just went, huh? Does that mean that they can start investigating any state, locality, Indian tribe, business enterprise? Are they going to investigate Google, some not-for-profit? This is kind of, insane in my view. Maybe that's a little strong language, but it's not an appropriate routine use. And I will say, Aptu commented on this system of records notice, and it did make comments on the breadth and vagueness of this particular routine use because believed that it, as I also believe that it did not really meet the requirements of the statute or OMB guidelines in any way. Here's another example. In the same system of records notice from Treasury, it says that they will disclose to a public or professional licensing organization when the information indicates by itself or in combination with other information of violation or potential violation of professional standards or reflects on the moral, educational, or professional qualifications of an individual who is licensed or seeking to become licensed. So what might this allow Treasury to do? To whom may they disclose the information? I mean, this says a public or professional licensing organization. Is there any limitation on what type of licensing organization that might be? No. Could be the bar, could be your medical or nursing license, could be your driver's license, could be a fishing license or a gun license or pretty much a business license to run your business. In the District of Columbia, here where I live, pretty much anything you do that relates to a business, you're required to have a business license. And under what circumstances is it permitted to, under this routine use to disclose information? Well, if you look at it, I mean, if you isolate the particular phrases, you'll see that one of the things says if it reflects on the moral qualifications of the licensee or potential licensee, someone who's even just an applicant. What does that mean? Who is judging what is the moral qualifications of a person? Does it require that Treasury's concern be at all related to a Treasury program? No. That they have any kind of federal impact? No. Does it require that Treasury has at least a minimum level of confidence in the truth of the information that they're sending? No. So if Treasury finds out that you donated money to an organization that they find morally inappropriate, like the Red Cross, I don't know, APTU, somebody that they just don't like, they're going to make a report to the state that holds your medical license or your gun license or bar license or causes an investigation to be open about you. You may think that's, kind of frivolous, but having an investigation open about you, I'm a member of the bar in 2 states, and that's a very, very troubling thing. It costs a lot of money. You have to be represented. It's not easy to be investigated, even if there's no merit to something. And then when we think, what if the organization is something that's more spicy, Planned Parenthood or a political party? This just seems like maybe it's a bad idea. And also, there's actually case law that specifically prohibits agencies for finding a place for any kind of schmutz that an agency digs up without it being related to agency programs and without it rising to a level of confidence to be worthy of opening some kind of inquiry. And so this is also a very troubling routine use that we saw and that APTU also commented on. Okay, I'm just coming to the end. And I want you to remember out of this talk 3 very important things. First, that routine uses, once in place, act as limitations. The language that you put in the agency puts in a system of record controls what an agency can legally do. And this explains why the language I showed you of routine uses can seem very arcane and legalistic. Again, the lawyers are trying to protect their agencies, and that's why, and they're trying to accommodate various case law, and that's why they can look like that. But they act as limitations and they are legally binding. Second, it's important to remember that the protections do not follow the record around. When a record leaves an agency that's covered by the Privacy Act and goes somewhere where it's not covered by the Privacy Act, it loses privacy protections. It can lose them. They're not going to follow the record around. So routine use disclosures are important because they might be sending a record to a place where it's no longer protected. Think about a record. Again, I use CMS as an example because I used to work at HHS. You have a Medicare record. Turns out that record is protected both by the Privacy Act and by the HIPAA privacy rules, if you know those. If CMS, for some reason, has a reason to move the record to the CDC, CDC is still protected by the Privacy Act, but it's not protected by HIPAA anymore. What if CDC sends the record then to the state of Georgia? Georgia is a state. It's not covered by the Privacy Act. It might be covered by HIPAA because state Medicaid agencies are sometimes covered by HIPAA and some other state entities can be covered by HIPAA, but maybe it's also covered by state law. The fact that it loses Privacy Act protections doesn't mean it's not covered by anything. It just means it's not covered by the Federal Privacy Act anymore. Finally, routine uses are always discretionary. In every case, on a case-by-case basis, the agency is obligated to consider whether the disclosure they're about to make is compatible with the purpose for which the information was collected under one of those 3 theories that I told you about. So just because a routine use exists does not require the agency to disclose. And that's very important to understand. Okay. That's what I have for the content of this presentation. Here are some useful resources for you. I want to point you particularly to the top link here, which has the APTU 4 documents, including the little 2-pager on the routine uses that summarizes what I've talked about today. It doesn't have quite as much detail. It has the primer on the Privacy Act. It also includes that 2-page mixed records, mixed systems that talks about what happens when people are in different immigration statuses. And it has a longer document that's a guide to how to read a system of records notice and how to think about it if you're going to comment on a system of records notice. If you have a little time, if you have a long time, red flags you should be looking at, questions to ask yourself. I think it's very useful. There's some other things here that are pretty self-evident. I will say the DOJ Privacy Act overview, it's from 2020, but it's a very useful compendium of all the cases if you're particularly interested on the Privacy Act. And that's what I have. So we have a few minutes. I'm happy to take some questions, and to the extent Aptu is willing, I can hang around for a little bit. I don't want to hold people up, but we've been asking questions all along, so I'm grateful for that. Thank you, everyone, for your attention. It's really been a pleasure.
This has been great. I'm going to try to get to a couple of the questions that we have here in the chat. You did get people with everything that you've just presented. You've drawn out some skeptics. Someone said, wow, relevant to seems extraordinarily vague and the basis for a wide range of violations of privacy. Am I right to worry about this?
Yes, you are. If a routine use says only relevance, if it only uses the word relevant, that's very broad and vague, and probably that's not a good routine use. Sometimes it will say relevant and necessary. That's something that narrows it a little bit. Necessary is a harder standard to make. But as I mentioned, these are kinds of languages that can be challenged in court, and people definitely have challenged them.
Right. And then back to your example about background investigations. Background investigations sound like fishing expeditions. What happens if an agency discloses without written consent?
Yeah, that's bad. So I've been through background as a federal employee. I've been through several background investigations. I filled out the long and involved forms. I understand there are sometimes similar things in the private sector. Background investigations are can collect very intimate information about all aspects of somebody's life, their education, their medical conditions, their military service, their employment history, their family, their travel, and so forth. So it's very important that when you do a background investigation on someone, that they know that that investigation is happening. If someone applies for a job, they should know there's going to be a background investigation. You should tell them, you should give them notice, we're going to do this, and you're going to sign here saying you agree that we can investigate you. And truthfully, that's a situation where they have a captive audience. If you say, I don't want you to do a background investigation on me, well, you don't have a right to a job. You have a privilege to work in places, and they can say, we're not going to hire you, right? But you can at least get notice about what they're going to do. You can give a heads up to people who they might talk to. You can decide who your references are going to be mostly in advance. The federal government, they're notorious for going to your references and asking for 3 more people that are not on your form, just in case. But yes, they should have consent. The only time when I didn't go into it, but the only time when you might not want to have, when they could possibly do it without consent is for the retention of somebody who is already in the contract or in an employment. In that case, if there's reason to reinvestigate somebody for a cause, you might not want to tip them off by getting their consent again to reinvestigate them or and the federal government has dealt with this by signing the original consent form that now says, we are going to continuously monitor and continuously investigate you. And so you've been on notice that we could investigate you at any time. And so they've sort of wiped out that possibility. And I think probably businesses are figuring that out too.
Great.
It feels a little bit not consensual, right? It feels a little bit coercive, but if you want a job that requires that kind of trust, then you probably have to sign those
Great.
kind of forms.
Maya, I want to thank you for being with us today. I know I speak for the entire Aptu community when I express how much we appreciate these resources that you've been making. For anyone that wants to go back and rewatch or share the previous recordings with colleagues, they are on our YouTube channel, and this one is going to be posted there within 48 hours. Also, if you'd like to see more events like this, please let us know by sending an email to info@aptu.org. And if you're not already getting our newsletter to stay informed about events like this, please subscribe. There will be a link in the chat to that. And I want to thank everybody for being with us today, and especially thanks to Maya.
Thank you so much. It's been really a pleasure.
Great.